Hi guys, Chris here with Super Savvy Travelers. We are still in Bari today and we're so excited because we have some really golden nuggets of information for you. Nick Metta from Studio Legale Metta has set up an interview with a Notaio and we're going to answer all your burning questions. So today we have with us Alessandro Armenio, and he is an Italian public Notaio. Alessandro, thank you so much for meeting with us today.
Thank you.
Let's start, and Nick is here with us as well. Let's talk about another thing that we see in Calabria quite a lot. And again, this could be a whole 5-hour special just on this subject. But what I want to talk about is Usucapione and active possession. Now, we touched on that, and I think what I'd like to talk about is, I know Nick has some solutions. What I love about Nick is he says there's always a workaround. There's always a solution. So if you can kind of explain what that is, and then we can let Nick talk about some of the ideas to mitigate that risk.
As I mentioned before, as a public notary, I make all the checks because I want to check the first deed, transaction deed, dated at least 20 years ago. So we have a purchase deed 24 years ago. I start from that deed until today. I check whether there is a continuous succession of transactions. Sometimes people come to me and say, okay, I have no deed. Just because it was abandoned, property was abandoned. My father went there 40 years ago, 35 years ago, and we started to sue the land and to live in the house, etc. We have had a continuous possession for at least 20 years. And I say, okay, this is the basic characters of Usucapione. You have purchased the property. You have been the owner of the property because you have possessed as an owner for 20 years. But unless a deed or unless a sentence issued by a court saying that the time has passed, that you have possessed continuously this land, you are the owner, but you cannot prove it. You cannot say it to anyone because it is not. It doesn't appear in any public records. So my legal advice is never buy a property coming from just a possession without having a deed that supports this possession. Yes, it may happen that in a previous deed, several parcels, several pieces of land have been sold, have been purchased, but just one piece of land in the center of the property has been forgotten. Okay, the situation is clear enough to say, okay, of course, you have possessed in the past 20-25 years all the lands around this parcel. Of course, you have possessed also the land in the center. So I say it's a risk not having a sentence of the judge regarding this piece of land, but you can be quite confident that the property belongs to the seller and you can purchase it with a reasonable tranquility. Okay.
Peace of mind, confidence.
Yeah, confidence.
Yes.
Okay.
Yeah.
You might have, even if you buy this property in this situation with an usucapione not declared by a judge in a sentence, this is a valid way to purchase property, but you might have problems in reselling this property or in trying to mortgage this property in order to obtain a law by a bank, because a bank wants to know, I don't want to know nothing about possessions. I want a deed.
Yes.
A public notary has to tell me that there is a deed.
Yeah. Okay, that's very important. So, as you know, in Calabria, we have a lot of that.
Yes.
So, and I know we've worked together on several situations like that. Each one seems to be radically different, so it could be very confusing. Maybe if we can touch on just some of the remedies for usucapione, and when would you not worry about it? Like, say somebody buys a magazzino for 3,000 euros. Is the risk reward ratio acceptable?
Sure.
Okay.
Yes, absolutely. And that's a very good point. And what he was saying, Alessandro was saying, there are situations that, like a piece of land in the middle of other plots that have all perfect record, obviously, like let's make an practical assessment of the risk. And specifically, yes, there are certain situations where the record is so clear that there is no indication that someone would come up. There's no past record, old record, plus the value of the property makes it also might lead you to go for the deal even if the title is not perfect, because at the end of the day the law will protect who has decided to take care of an asset that's been neglected. So if a magazine is sold for 3,000, let's say, as you were saying, most likely it is not in perfect conditions.
Right.
It is not like fully furnished with nice floors and finished, fully finished, I meant. So most likely that is almost more of a health hazard for the public,
Right.
because being neglected, people might go there like homeless, or people want to do store or dump their trash. Sometimes it happens. So the law will say, okay, if you buy a neglected property, you start fixing it, invest money, finish it properly. Perhaps you even do the structure. You redo the roof and things like that, because there are leaks. And so my recommendation. So the law will tell you that if you had purchased it in good faith, meaning without knowing that you were still in the property for someone else, then if that someone else comes to you, all that they can get is the value of their entitlement at the time of your purchase. So if the magazzino was worth 3,000, and one of the 1,000 heirs that might be entitled to the magazzino all of a sudden comes back from wherever their ancestors had emigrated to, or wherever they are, and they say, well, I own a fourth of that magazzino. Well, all you might get to is 750 euros. Or if you want the magazzino back, you need my 60,000 that I invested to fix it up. Or if my 60,000 now make it worth, because of the value that the town has created around it or whatever, makes it worth 100,000, you owe me 100,000 less than 750. So you know what? I'll give you 500 euros and you go away, because to pursue the claim of 750, probably you have to spend twice as much in lawyer fees.
Right.
So our advice to our clients is, we'll give you a risk assessment.
Yes.
And practical advice. Yes, there is not a perfect deed here, but what are we talking about in practical, life terms? You know what I mean? And risks. Now, if you were not that in good faith, let's say, and you knew that there is someone in the family who left the country, let's say, 20 years ago, 19 years ago, and everyone knows that they are having a good time, and they're doing very well in the U.S. A lot of people immigrated.
Yeah.
And you know that they just left it behind. So you know what? I'll take my chances. It's only 1 year after 20 years, or it's only, take a chance of time. Plus, okay, I'm not in good faith. Still, the law will give you some remedies. In that case, will not be the highest between how much you invested and the value, but will be at least the money that you have invested.
Okay.
So once again, would a person who is doing pretty well or whatever come back for X amount of money that you're risking? And if they come back, will you be prepared to spend that money? So you talk with the seller and say, listen, there's this risk that has this money value. Will you take half of it or all of it off of the purchase price? Or the seller might tell you, yeah, I'm selling it for 3,000, but there is a real estate appraiser or surveyor appraiser saying that if the title was in order, we'll go for 6,000.
Yeah.
So you're already getting your risk deducted from it.
What Nick is saying is that there is no one answer to that question, because it depends also on what you want to do with this property. Okay, you want to make it your holiday vacation for the next 20 years. Okay, you can take that risk. You want it to renovate it and resell it to have an increasing of your money, future capital gain. Okay, but you can you have to be advised aware that maybe you cannot resell this property because of that problem.
Yes. Okay, that's very important.
Yes.
I think the resale part is really the most.
Yes, and there are also sometimes, especially when there is an inheritance in the middle that messes things up, there are title insurance that are available.
Oh.
So the seller yes, the seller many times will say, hey seller, there's this issue.
Yeah.
Our buyer is okay taking the risk if you issue a title insurance. So title insurance, there are specific insurance company that will issue title insurance, and the cost is not impossible, and it's not as high that if the seller doesn't want to pay for that, the buyer can buy it for them for their own safety. So
That's a
many
good
times
idea.
you tell the buyer, especially for higher end properties
Yes,
like
uh-huh.
300-400,
Yeah.
the seller will not issue title insurance, which is, by the way, 950 1,000 euros. So it's
Oh, that's nothing.
It's not exactly.
Yeah.
So the seller will not issue it. We recommend that you pay for it because the seller is the one who has to sign on it. You are the beneficiary as the buyer, and the insurance, title insurance, is to be done in a specific manner. We tell our clients, you don't want you to be the beneficiary. You want to be the owner at the time of whatever claim. Because when you sell it, so your buyer
That's right.
doesn't have to do it again, as you were saying. So, of course, yeah. So,
And that's actually a great added benefit to a buyer that comes in on something
Yes,
like that. I didn't
definitely,
even know
because-
that existed here as title
Yes.
insurance.
Yes, it's so you are absolutely right. Having done real estate transaction in the U.S., title insurance is part of every single transaction, and that what actually makes up for it. The notary in the U.S. not being a legal advisor like notaries in here.
It's usually the title company.
Yes, here the notary has a title insurance liability built into their professional liability insurance.
Okay.
So every notary, so that's why the prices between notaries in Italy and title companies are comparable, because in the US you will pay separate title insurance, which is almost built in. The notary will not charge you for title insurance because he is or she is already paying their liability insurance, and if something goes wrong, the notary is liable, and they will bring their insurance.
Now that brings up a point. I have seen in certain acts that the notary is saying, I'm not liable.
Yes, do you want to talk about that?
Or there are some fields, some aspects of the deed in which the public notary is not responsible, is not liable.
Okay.
What you say in the deed, and I certify that you have said that, it doesn't mean that what you say is true. If you say, okay, I'm leaving the property in 2 months from now, I can certify that you want to do that, but I don't take any liability regarding the fact that you actually leave the property.
Okay.
Or something like that happens in building permits. Okay, we have building permits. We see the building permit, we see the cadastral perimetry, and we see that they are compliant. Okay, they are comparable.
Yeah.
But sometimes what we see in the perimetry is different from what is in the fact, what is in
reality.
reality.
Okay.
And if so we cannot take any liability and a responsibility if the seller having a building permit has a little or not little changed the works done in the property. So we cannot take this liability. That's why we suggest to go to an attorney or to an engineer or to a surveyor to check whether what is in the papers is actually in the reality.
Okay, that brings up a good point, because when we're in Santa Domenica Tlau, we tour with the architect, and he comes with us to the act, and he verifies that the floor plans are correct. Okay, that's a good point. I hadn't thought about that because I just left that to Antonello, but if we're not using Antonello, it would be important to get somebody to do that.
Yes.
Okay.
Yes, more than 50%, based on official statistics, more than 50% of properties in Italy have some building violations that will actually, if detected, will make the property not a fit to be sold by law. Meaning the notary, if the notary realizes that for whatever reason, even just because the parties split it up by mistake, that there is an extra bathroom that has extended the size of the place beyond the building permit footprint, the notary doesn't cannot go ahead with the transaction because the taxable value of the property is smaller for a smaller unit.
Yes.
And if you have built an extension, you have to make sure to get a permit for that. But as a consequence, the property taxes will increase. Like in the US, the assessment will go up, you pay more taxes. And since the sale taxes are based, the transfer taxes are based on the assessment value metering, not the purchase price. Right. The notary is a tax collector, actually. So he has the duty to collect taxes. That's another huge difference. Right. So if he perceives that there is no compliance that affects taxation, obviously that's the most severe probably of the one of the most severe reasons to, or basic reasons I should say, to not go ahead with the sale.
That's a good point. And in fact, I've seen a couple properties recently that had some abusive things. There was a whole room put on, and they said, well, we're giving you that as a gift. We're not going to include it. But still...
If you go to the notary and say, we are okay with that, and notary will say, now that I know, I cannot not know.
Exactly. See, that you, and then you would not be able to do that, right?
There is a gray zone in this situation. Okay, let's make two examples, very different examples. We have a building permit that allows you to make a house of 100 square meters with 2 rooms, a storeroom, and a bathroom and a kitchen. Okay, but the room is, one of the rooms is 20 square centimeters larger than expected. Okay, that's abusive, but it doesn't make the property not
suitable for sale.
Okay, so you can purchase it. The public notary, even if he knows that, can go on if the planimetry is compliant. Okay, this is the first example. Another example, you have a building permit like the one I mentioned before, but you built another floor on the ground floor. Right. Well, that's a totally different situation, and the property is not suitable for purchase. Okay, and the public notary stops. Between these two examples, which are really extreme, we have a gray zone. What happens if we have a building permit for doing a 250 square meters room house, but we have enlarged it with just 1 bathroom or 1 room of 10 square meters? I don't know. That's a situation where the sensibility of the public notary intervenes, and there are notaries that would say, okay, I do not agree in, even if you know that there is this abusiveness, I don't agree in notarizing this deed. And public notaries that say, okay, this is not a major modification, so I think the building is suitable for the closing for the deed, if you both know and we write it in the deed.
Yeah, okay. However, in this particular situation I'm thinking of, there's a whole bedroom suite that was added that was abusive. Now, you wouldn't be able to sell that house at all, even if they said, we're not including it in the cadastral plans and we're not charging you for it. No, first of all, I would never recommend that, but secondly, I think you couldn't sell it, could you?
If something is not in the cadastral planimetry, the public notary has to stop, because in the deeds, the seller has to say, okay, the planimetry that the public notary is showing me is exactly compliant
matching the reality.
Exactly.
The reality.
Exactly.
Okay. And if the public notary knows that statement is not real, is false, he will not notarize the deed.
Yeah, there are serious penalties for false statements.
Yes, there are penalties, but that's what we are for. We Italian notaries are for certainty of the transactions and for the irregularity. Nick mentioned that we collect taxes, so we must be assured that the state gets the money for taxes.
Okay.
And taxes are related to the extension of the property.
Okay.
And not only for that reason, but also because if you have made this bathroom in an area which has some persistent
Landscaping restrictions.
Yeah.
limitations. You cannot. It's just a small bathroom. No, it's a small bathroom in front of the Colosseo.
See,
Do
yeah,
that.
exactly.
Yeah.
Yeah, okay.
Or on a riverbed.
On
You
a
can
river-
Yeah,
do that.
yeah.
Yeah,
This,
yeah.
this is might mess up the course of the river.
Yeah.
And there are so many restrictions. Or it's too close to your neighbor. Or so many
Or
restrictions.
to a road, a public road.
Or to
Yeah.
woods. To
woods,
a
yes.
public road. Yeah.
Yeah,
So
yeah.
there are so many restrictions. So you cannot just as a notary, as I was saying, once you know about it, even if everyone is okay, you cannot.
You cannot. So for that person, and the seller has to go back and do something. They have to get permits for that. They have to pay back taxes for that. They have to
So,
put it
yeah.
right.
Yeah.
Okay.
Yeah, if it is possible. If landscaping and all, because there are several levels like municipal, regional, and state
Yeah.
building permit restrictions,
Yeah,
let's say. So the seller has to first check, can I fix the paperwork?
Yeah.
If the paperwork cannot be fixed, unfortunately,
It's not sellable.
the seller forgets to mention and the buyer doesn't realize that there is an extra bathroom and the notary never knows about it, and everyone will sign on a blueprint that doesn't have the bathroom, and everyone in good faith says everything is okay, because many people just go through the reading it without really paying attention to every single
Yeah,
word.
yeah.
It's like, what, 5 pages now? I look at some old, like 20-year-old purchases, like a page and a half. Now it's like 6 pages of statements. So people start talking about other things with the notary.
Yeah.
I'm reading.
Yeah.
You know, it's so long. So sometimes things slip through the cracks. So
Yeah.
that's why we tell buyers, the fact that the property was purchased 7 years ago doesn't mean that it's fully compliant, even
That's
if
right.
the seller hasn't
That's
done
right.
anything. Also because in 2011, I think, 2010, 2011, building compliance regulations got stricter, and notaries at that point had to do an extra level of paragraph reading
Yeah.
because of that. Like this statement
Yeah.
that the seller has to make about the planning matching the reality
Right.
is something pretty recent compared
Okay.
to the history of Italian conveyancing. Yes.
Yeah.
Sometimes though,
Yeah.
depending on the situation,
Yeah.
if you get a surveyor says, okay, I did my homework, you can fix the bathroom.
Yeah.
So the seller will just sell someone else, because in Italy there are Italians who will say, you know what, I'm going to pay less taxes if I ignore that
Yeah,
portion.
yeah.
So I'm going to buy it as it is, and I'm going to say to the notary that I'm okay, that it matches
Yeah, yeah.
the plan.
But isn't that a false statement?
It is.
There are penalties.
It's very loosely.
Is it?
Yes,
Okay,
very loose,
okay.
Yeah. So we tell our buyer, okay, you got a surveyor statement saying that they checked all the regulations. You can fix it.
Okay.
It will take 4 months.
Yeah.
But you can fix it.
Yeah.
So what if we negotiate with the seller, take a little money off just for me to handle the paperwork,
Yeah.
and I'll give you 80% of the price in escrow or whatever, and I'll take care of the work, I will fix the paperwork, and then we close.
Yes.
The sellers might say, you know what, I'm getting the money I want when I want it,
Yeah.
you're taking care of the problem, you're fully responsible. Of course, you as the buyer take full responsibility for applying for the permits, doing all the paperwork, paying extra taxes. You waive your right to claim that the property now is costing you more for transaction taxes.
I see.
And stuff
Okay.
like that.
Okay.
And the seller will have to be on board with it, because the seller is the one who has to have his or her name on the application to fix the property.
Oh,
compliance,
okay,
because
okay.
it's his property.
Right.
He's or she is the only person entitled. So once all is done, you go to the notary and make true statements at that point.
Okay. Okay. That makes total sense.